So my name is John Burgess. I'm the Executive Director of the LLM program, and I'd like to welcome everyone to one of our regular high table lunches. As I've mentioned, we will have by video recording today guests from the arbitration group at Freshfields, and we're delighted that they'll be able to listen as well, and delighted to see everyone here. We'll forego the usual introductions, I think, partly because I think everyone here knows each other at this point, and we've been able to do that several times successfully. And of course, the inevitable cliche would be to say that Professor Salacuse needs no introduction, but as the cliche goes on, I'll nevertheless make a brief one, which is only to say that he needs no introduction partly because of what he has done here at Fletcher over the years as a teacher and a mentor. I know he's working with one or two of you on your capstones, has taught investment law, law and development, negotiation, corporate governance, leadership, and speaking of that and leadership, Professor Salacuse also was dean at the Fletcher School, and before that at Southern Methodist University Law School. So the full range of academic and educational activities. But the real point today is to draw on his expertise as a scholar and as a practitioner in international arbitration. Professor Salacuse has been chair of the Institute of Transnational Arbitration. You've been very active, both I think as, I believe they're called presidents, and members of arbitral panels, including for the Center for Settlement of International Investment Disputes, and in the tradition of provocative and significant titles, our topic today is Inside Investor-State Arbitration, the secrets, no quotes, of a, quote, secret panel. And I'm sure that punctuation has some significance, and thank you so much. I'll turn it over to you, and I'll be happy to advance the slides as you tell me to.
Thank you, John. It's a pleasure to be with you today. And I began thinking about this during our election campaign, when one of the big issues in the election campaign was the Trans-Pacific Partnership Agreement that we had been negotiating with 12 other nations. And that agreement had an investment treaty embedded within it. The opponents began to complain about it and charged that one of the problems with the Trans-Pacific Partnership Agreement, there were many, is that there had provision for a secret tribunal to hear these cases, and it sounded very nefarious. The secret tribunal, these judges, mysterious judges who would meet in secret and decide things. And then one morning I woke up and I said, hey, I do that. That's what I do. I'm one of those guys who is very nefarious. So I thought about that, and I thought I want to talk to you about that. And yes, there is a reason I put quotes around the secret tribunal, because I think they're not that secret. There is this provision in Rule 6 of the International Centers of Investment, the Settlement of Investment Disputes rules, which govern arbitration, which says any time the arbitrator is appointed, the arbitrator must sign a statement that says, I shall keep confidential all information coming to my knowledge as a result of my participation in this proceeding, as well as the contents of any award made by the tribunal. Okay, my interpretation of that is that once information has become public, it's pointless to try to keep it confidential. And there is a great deal of information that is now public. Most of the awards made by tribunals are published unofficially, sometimes officially. If you go to ita.com, I think you'll find, for most of the cases, you'll find all sorts of the pleadings, or not the pleadings, at least the decisions relating to those cases. So I do not intend to violate my commitment, so I will not be revealing any secrets, but I do want to kind of talk about this phenomenon, which is, I think, a very important part of international law today. It all begins with investment treaties. The countries of the world for the past 50 years have been in the process of building an international regime to facilitate the flow of capital. And they have done that with an important set of instruments, or one instrument in particular, which is the investment treaty. So as you can see here, there are bilateral treaties. There are 2,900 bilateral investment treaties. There are some 300 or so free trade agreements and others that, because most of, when you hear about the free trade agreements, most have embedded within it an investment treaty that also provides for investor-state arbitration, one of the secret tribunals. You'll see that there are regional treaties, the Energy Charter Treaty. So I estimate there are 3,300 plus investment treaties that have been negotiated in the world. And that certainly represents, when you think about human activity, human energy by jurists, lawyers, and negotiators over years, that represents a substantial investment both of time and energy and money in order to build this. And it is a manifestation of globalization. It's an attempt to create one more global set of networks that will facilitate the flow of capital, just as there is a trade regime. This one has been built essentially bilaterally through a series of bilateral steps rather than multilaterally. Okay, so what's an investment treaty? Let me boil it down. An investment treaty is, first of all, we're talking about an instrument of international law, not a contract between private parties. It is a sovereign agreement between sovereign states, and it is subject to international law. So it's just, and in those treaties, states make commitments to other states on the treatment that those states will accord to each other's investors. So France makes a treaty with Senegal saying that they will give a certain treatment. We will not expropriate you, we will treat you fairly and equitably, we will allow you to transfer funds. And that is, and Senegal grants the same right to the French. That's the way the thing works. Okay, so far so good. This, however, has a problem. The problem of making those kind of commitments is what I call the Don Giovanni problem. I don't know, do you know the opera Don Giovanni? Don Giovanni, Don Giovanni, it's a wonderful opera by Mozart. And the Don Giovanni problem is that Don Giovanni seduces hundreds of women by making promises. And there's the wonderful aria by Leporello, who is approached by one of Don Giovanni's jilted women, and he says, listen, don't bother with this guy. This guy is, and he begins to enumerate how many women he's seduced in various countries. So many in Germany, so many in France. And then he finally, he says, and on España, mil tres. And in Spain, 1,003. So this is the problem. So the problem then is, what do you deal with that? And it's the same thing if you don't like opera, but you're more moved by modern Western music, popular music. It's the old song, I think it was written by Carole King, "Will you still love me in the morning?" And that's what investors wonder. You have said to me, you're going to treat me fairly and equitably. You're not going to expropriate me. You're going to give me all these rights. But will you still love me? It's saying to this host state, once I've built that resort hotel for $100 million, once I've sunk $500 million into the mine, how are you going to treat me then? So there has to be some way of making a commitment, a real commitment, and this is where we come to investor-state arbitration. It agrees on a mechanism for the enforcement of these commitments, to make them real commitments, to have some hands-tying capability to prevent states from reneging on the promises they make. And the whole idea is we are trying to encourage the flow of capital, and part of the flow of capital is dependent on the commitments that the host states will give to the capital once it enters their territory. Okay, I'll just give you a sense of what this is. Among these 3,000 treaties, there's a remarkable similarity. It's almost as if the same guy was drafting the treaty among all 3,000. You'll find the same language.
Same word processor.
You'll find it's probably the same word processor. You'll find words like fair and equitable treatment, full protection and security, expropriation. These basic concepts are the building blocks of international investment treaties. So again, I kind of set out the structure. But let's take a look at the investment dispute settlement. So maybe there really are two categories. One is investment. There is dispute settlement between the two states. So if there is a dispute between the two states, as in any treaty, there's usually a method of settlement, and in this case it's arbitration. Ad hoc, state-to-state, interstate arbitration. With respect to the investor, there's a second classification. This is really a novel and very powerful instrument that's being given to private investors. This investor-state arbitration provides that the investor itself, a private party, can sue a sovereign state. A foreign private party can sue a sovereign state in international arbitration if that investor believes that its rights have been violated. So it can do it on its own initiative. It doesn't have to ask its home country. Can I sue? If I'm French, can I sue the Senegalese government? It can do so autonomously. It's compulsory. The treaties basically provide a standing offer by each state to the investors of the other state to arbitrate in cases of dispute, and the acceptance of that comes with a request for arbitration. So you have under basic contract law, you have an offer, a standing offer by the state, and it's accepted when the injured investor or the aggrieved investor decides to arbitrate. And it is a process that's governed. This is not private international law, it's public international law. It's governed by the treaties of concern, and I'll talk to you about that in a bit. So what's arbitration? I find sometimes students confuse it with mediation, where we kind of sit down across the table and we talk and we try to work out our problems. This is not arbitration. Arbitration is a legal process where the arbitrators are authorized by the parties themselves, by agreement, to decide their dispute in accordance with agreed upon rules and principles. So it is a judicial process, or a quasi-judicial process. The arbitrators are exercising judicial power to interpret the treaties and to apply the treaty language to determine whether there was an injury, and if there was an injury, to provide for a compensation. So this is what we're talking about in international arbitration. This is not mediation. This is not the negotiated facilitation. This is a very judicial process, and it is one that involves lots of lawyers. So I just wanted to kind of get that down. Sometimes I think there's an acute confusion over what arbitration is. Okay, the arbitral tribunal is functioning under international law. It applies the relevant treaty provisions. So there may be if there's a conflict between French investors in Senegal, they will apply first of all the France-Senegal bilateral investment treaty. They apply the ICSID convention, or there may be another convention, but the International Center for the Settlement of Disputes is an international institution affiliated with the World Bank. It's a separate international institution governed by a convention. Probably 150 countries belong. Probably I think all of you, whatever country you're coming from, is a member of ICSID. Whatever country you're coming from, I think, has signed at least one bilateral investment treaty, and often many, many more, because countries that are seeking to attract investment use the treaty mechanism as a way of promoting investment. And if you look at the title of any bilateral investment treaty, begins a treaty to promote investment. That's why we're doing this. And you do it by making promises and then giving the assurance to investors that if we don't live up to our promise, you will have recourse in a legal forum. There'll be principles of international law govern, including the Vienna, because when you have treaties, you have to interpret. So therefore, the Vienna Convention on the Law of Treaties is applicable, and there may be applicable principles of national law. So this is kind of the legal framework, the legal resources that the secret tribunals draw on. Investor-state disputes are very special. They're very different from private disputes. Now, this is not a contract dispute. Understand this. This is a dispute about whether a treaty has been violated, and that violation is a question of whether a state has lived up to its international commitments. So first of all, a private party compels a foreign private party compels a sovereign state to answer for its acts. That's basically what they're doing. And that's a really powerful and novel mechanism, because before the treaties, there was no real mechanism for an aggrieved investor to directly confront the host state. In those days, the recourse at that time, before the treaties, was basically diplomatic protection. You go to your home state and you say, hey, they've injured me. What are you going to do about it? Your home state will try to negotiate some sort of solution to the problem. Second of all, it's governed by international law. This is not a contract dispute, which is governed by the law of the contract. This is a dispute under international law. Third, it involves public policy issues. Because any time a state has acted, most of the time, when a state has expropriated an investor, when a state has decided to change the contractual terms of an investor, it usually justifies it on public policy grounds. We are expropriating because it's in the public interest. We didn't do this, and they can justify it because, look, things have changed. Well, we have a new economic regime that's come to power. We've been elected. We're going through that now here in this country. We're going to see some new changes. So now we're going to change the terms of our agreement with you. Meanwhile, your investment has already been in the ground. You are committed. You can't take that power plant and bring it home. You're stuck. So it involves public policy issues, and it also involves long-term economic relationships. These are not contracts about exchanges of goods. These are contracts about commitments made to build a power plant, to build a hotel, to build a road, to build a communications network. Long-term relationships that cannot easily be undone. And it involves large amounts of money, significant amount of money, and these are also
Go ahead after you.
Yeah. Costly. These are very costly because they are big cases that involve big law firms, and many lawyers. Often you have to do things in 2 or 3 languages, so the costs mount up, and the time to bring those cases to an end often can stretch over many years. So these are very special kinds of disputes. Let me just give you an example of kind of a rundown about the number of investor-state arbitrations that have taken place. So far there have been, this was as of end of 2014, over 600 cases that have been launched. And probably every country in this room from which you come has been a defendant in one of these cases, and sometimes many more. The United States has been a defendant, a respondent in these cases. So this is not something that's kind of totally theoretical. I used to lecture on international investment law to a group of every summer to a group of foreign lawyers who would come here, and I started that maybe 20, 25 years ago. And when I got to the international investment law, everybody their eyes glazed, so what, it's not really relevant. Then suddenly, about the year 2000, I noticed that there was a great deal of attention. because suddenly people kept saying to me, the lawyers there, hey, we're really interested in this. Because now we have a way of bringing a case against the state, which is one of these investment treaties. So we have 99 governments, there's probably more now, have been at least a respondent in one case. 40% of the respondents were from developed countries. 60% are from developing countries. You even have cases within the EU. So I'm involved in a case right now where German investors are bringing a case, not under a bilateral investment treaty, but under the Energy Charter Treaty. You know about that one? You probably don't. But I think you're going to see more and more, because there are some 20 cases outstanding where German investors who invested in the solar energy sector in Spain are bringing cases against Spain on the grounds that the Energy Charter Treaty had been violated. 405 cases have been so far concluded. 36% are in favor of the state, have been decided in favor of the state, 27 decided in favor of the investor. You get about 26 that get settled. So this gives you a sense. I sometimes when we talk about these tribunals, and I talk to some people, particularly from the NGOs, well, they say it's stacked. The thing is stacked, or I guess rigged is the word we use these days, rigged against the small developing countries. This is not true. You can see that 36% of the cases really have been decided in favor of the states. Let me just go to the next one. This kind of gives you a diagram this is from UNCTAD, of the growth in investor-state disputes. From basically nothing in 1987, very, very few, to some over 600 now. And I think it's growing. This will give you an example of some of the awards. To the Czech Republic, there was an award of 270 million. Here against Ecuador, 71 million. 824 against Slovakia. And in one case, this was the case that I was the president of the tribunal for, 405 million against Argentina. So these are big, big decisions that involve major expenditures of funds to litigate and also often result in awards that are quite substantial.
Could you just give a couple of examples of the subject matter of those?
I'm coming, okay. No, that's good. Subject matter could be anything. I mean, it could be expropriation. And what we're seeing now is a different kind of expropriation. It's not the expropriation, where the military arrives and seizes the mine, throws everybody out, walks away. It's a different kind of expropriation, which is often called regulatory expropriation, where the regulatory system or the contract between the state and the investor, the terms are changed unilaterally, and suddenly the profitability of that investment declines drastically. So the issue is that an expropriation? I will give you an example shortly, but let me just kind of talk to you about the stages. This is, each arbitration is governed by a set of rules. This is not free-flowing, let's sit down and make a deal. This is a legal process that is established by rules and often by the treaty itself. So first of all, you have a request for arbitration, and that follows a certain. And in the case of ICSID, ICSID is not the International Center for Settlement of Investment Dispute. It is not the only facility that manages and administers arbitrations. There are others, but in the investor-state area, it handles the majority. There's the Stockholm Chamber of Commerce that handles them, the London Court of Arbitration, the International Chamber of Commerce. They each have their set of rules. ICSID has its rules. So then it is registered by the Secretary General. And then finally next is you have to constitute the tribunal. Constitute the tribunal means choosing the arbitrators. There is no standing body of arbitrators. They have to be selected ad hoc for each case. And the usual formula is that each side appoints an arbitrator. Now, just because one of the sides has appointed an arbitrator, does that mean that arbitrator represents that side? The arbitrator must decide and work independently. And if that arbitrator is not independent, he or she can be challenged. So, and then then the third, the president is to, first of all, the parties will try to select the president by agreement. And if they are not they cannot agree, then the president will be selected by an appointing authority, and in the case of ICSID, that's the president of the World Bank. So that's the formula in order to try to get the group. Then you start with an organizational phase where you get the parties together and you talk about the procedure and how what's going to be the schedule for filing the pleadings, what languages are we going to do this in, and also the very important question of depositing for costs. Because courts are financed, national courts of course are financed by the public treasury. Arbitration is financed by the parties. The parties will make a deposit, if you will, a down payment on the expenses of the arbitration, and then as the arbitration progresses, they will draw down on that amount, and if the arbitration continues beyond what was originally estimated, a second, third, fourth contribution will be asked from each of the parties. You will then have the claimant's memorial. Claimant will set down in very legal terms in a memorial, a brief, and they usually run several hundred pages, with appendixes that usually you have an appendix of factual appendix with the affidavits of various witnesses, and you will also have a legal appendix of the various cases that will be cited as part in support of the plaintiff's case. The respondent will either file a counter memorial or make a jurisdictional challenge. And many states will, in this case, say, no jurisdiction. And we'll tell you why. There's no jurisdiction because the tribunal does not have jurisdiction over the subject matter. The tribunal does not have jurisdiction over this particular case because the investors are not protected by the treaty. So that there is often a jurisdictional phase that is decided upon to determine whether or not the tribunal is authorized to hear this case. And if the tribunal said no, we don't have jurisdiction in this case because it's the wrong investor, it's because of the wrong subject matter, then the case ends right there. Then we have a counter memorial for depending on the decision on jurisdiction. If the case goes forward, then the respondent will file its pleadings on the merits. Then there will be a second round of pleadings. Finally, there'll be submission and hearings. Often there's a hearing where the witnesses will come and testify. When we come to the merits, there are two aspects. One is the merit itself. Has there been a violation of the treaty, and if so, what is that? And then finally, there is the question of damages, or as international arbitrators like to refer to it as the quantum. They like Latin, like other lawyers. And then finally, a decision has to be rendered. Decisions are made by a majority of the tribunal. Later on, there may be challenges, enforcements, and appeals as well. So this is kind of giving you the phases it goes through. But I also think that there is, just to break it down into three aspects. One, jurisdiction. Second are merits. And third is quantum. That's what it goes through. And often the process itself may be bifurcated or trifurcated into three separate parts with three separate hearings depending on the complexity of the issues involved in each of these hearings. This is this is my secret tribunal. Very nice people. This is us. This again is not a confidential photo. This appeared in the ICSID annual report. The man on your left is Professor Pedro Nakin. He is a Venezuelan, an expert on human rights law, also an experienced arbitrator. The woman in the middle is Professor Gabrielle Kaufmann-Kohler, professor at the University of Geneva. Really one of the most
experienced arbitrators, international arbitrators that I can think of, and the guy on the right. So we were together on a case, I think it was about 10 years. A very congenial bunch. We got along extremely well, and dealt with a variety of issues. I think, John, you want me to start at what time?
Let's see if we could go for another 10 minutes.
Okay,
or
I want to
so.
get back to,
Yeah.
because I think, I want to give you an example of this case, and just to declare, for the sake of transparency, this was a case in which Freshfields, and I didn't know that they had requested this, but Freshfields was counsel to the investors, the claimants, in this particular case. And this had to do with the privatization of the water and sewage system of various cities and municipalities in Argentina. As you know, in the 90s, privatization was pushed by the World Bank and others when the many countries felt that their public services were in disarray, and they were in disarray, or they weren't efficient. One way was to try to bring in foreign investors to invest new fresh capital and to invest managerial skills. So this involves water and sewage system. I know it's very unexciting. Those of you who want to talk about high tech and
Trump
Silicon
resort.
Valley, but I don't have that kind of case for you. This is water and sewage, but water and sewage, of course, is fundamental to public health. Water and sewage is fundamental for the livelihood and manner of life of millions and billions of people. So, in 1989, the legislature in Argentina felt that its public services were falling apart. So it had adopted a state reform, said we got to reform. And in that, it provided for the possibility of privatization. And that was followed up by the privatization decree, which set up basic mechanism to privatize various sectors, not just water and sewage, but others. Then, but nobody came. Nobody was interested because Argentina was suffering from significant inflation. So what the Argentine government did under a finance minister who was at that time the lion of international finance, Domingo Cavallo, he said, we're going to have a convertibility law. We are going to lock the Argentine peso and the dollar 1-to-1. And they set up a legal structure to do that, saying basically there could be no more pesos in circulation than there were dollars in reserve. So we always have the ability to convert pesos to dollars. And this gave the investors some confidence. So then you begin to have, also as part of this process of trying to attract investment, Argentina signed 57 bilateral investment treaties. That's a lot of treaties. When you think about what it took to go out and negotiate that, so they signed 50, again, it's all part of the process. They then enacted a water decree, providing for investors and said basically, investors who come in, we will set them that they make from the revenues of the water and the sewage, we will try to assure them a reasonable profit. And that was set up in law. Then you have bidding rules. They said, okay, we're going to set up a process whereby foreign consortia or foreign investors come in and bid on the right to take over the water and sewage system as a concession. They don't own them, but they're going to run them. And they will run them and invest money in them. And from the fees paid by the users, they will have to make enough money to get their investment back and a reasonable profit. That's the way the structure worked. So, now John, we're going to go back. So there were bidding rules, and there was a consortia consisting of, an international consortium consisting of Spanish investors, French investors, and an English UK investor that bid and won the right to take over, and they got a 30-year concession, which would run from 1993 to 2023. whereby they would have obligations at the beginning. This was, if you will, a project finance vehicle. They would invest up front lots of money to improve the system. Then they would have the right to manage the system, and they would collect the fees that were paid every month by the water users and the sewage, those whose sewage was taken away, and ultimately get, at the end of that time, they would have get their whole investment back plus a reasonable profit. That's the way it was supposed to work. And so you have French investor Suez, you have Akbar, Spanish, Vivendi, French, and AWG, which they formed the ASA. ASA was the Aguas Argentina SA, corporate vehicle, that it won the concession and it took over the management of the system. They formed they contributed 120 million in equity, which was to be invested, because there were specific, in the investment, if you looked at the contract, there were specific obligations on the part of the investors to invest to improve both the system. And in order to, but what they needed was more than 120 million, as in most project finance operations, they borrowed. So they borrowed from the multilaterals. You know what the multilaterals are? Multilaterals are regional development banks, like the Inter-American Development Bank, like the African Development Bank, like the International Finance Corporation of the World Bank. They lent money to ASA to finance the required improvements of the water and sewage system. They did this not only for, I'm going to talk only about Buenos Aires, but there were at least 3 other municipalities, the province of Santa Fe and the province of Cordova, which were also went through the same phenomenon. So the revenues were to be derived from the consumer payments. The pricing was, now the problem is, of course, you've given a monopoly over a vital service to some foreigners. So the issue is, so you don't want them to be able to charge whatever they want, because you put them in a monopoly position, so the pricing has to be regulated. So this is subject to regulation. And the regulation, how it was going to be regulated, was stipulated not only in the regulations, but in the concession contract itself. And so from 1993, when it started, to 2001, the project was profitable, was going along fine, and substantial improvements were made. A couple of million people had water that they didn't have water before. That had water before, and I'm talking about same way with sewage. The system was expanded to cover larger areas, and you had various statements by public officials saying, "Hey, these guys are doing a good job. This is fine." Okay.
We have about 5 more
Yeah.
minutes, I think.
So you come to the financial crisis of 2001, when this is really a serious crisis, social crisis, political crisis, financial crisis in Argentina. It really was extremely difficult. So a lot of changes took place, one of which was that basically the convertibility law was scrapped, and the peso was devalued, I think 2/3. So suddenly what was a profitable project was not profitable anymore, so the investors then turned to the government and said, okay, we have the concession agreement which talks about changes and the ability to increase prices whenever these changes happen, one of which is the devaluation of the peso. We would like now to increase our pricing so that we could continue to be a profitable venture. And the Argentine government said, no, can't do that. And they refused. The investors pointed to the specific language, and that was ignored. And ultimately, the investors were no longer able to service their debt to the multilaterals. The multilaterals then turned to the investors and said, okay, you guaranteed those loans. You need to pay up. So they did. And ultimately, negotiations took place between the government of Argentina and the investors. Nothing happened. Finally, the investors in 2003 request arbitration, and then in 2006 the concession is terminated. So what you have then was Suez brings a case, the investors bring a case, you have 4 claimants, 3 treaties. So we had a jurisdictional phase, and this one went down with hearings, almost a week of hearings on jurisdiction, where the parties came in and argued about whether there was jurisdiction. I won't get into the details. The tribunal said no, there's jurisdiction is founded. Let's move on to the merits. Then you had the merits case, and there the claimants made 3 claims of treaty violation. One was expropriation. The second was denial of full protection and security, and the third was denial of fair and equitable treatment. Argentina defended on the grounds of necessity. I won't go into the details. If you want to see the documents on all these, I advise you to go to ita.com, and you'll find that all there out in detail. Ultimately, we said no expropriation. We said no denial of full protection and security, but the tribunal agreed that there was a denial of fair and equitable treatment. And I tell you, and often the tribunals are accused of arbitrariness because of the way we operate. And the problem is you've got to turn the states involved, in their wisdom, have given us this thing that says, fair and equitable treatment. Treat these people fairly. If you haven't treated them fairly, then you can impose damages. Well, what's fair? I mean, what do you really want to know? So we were all puzzled. What does that mean? There's lots of disjuris. So I was puzzling over this. This is my own story. And I said, well, who knows about fairness? I said, philosophers know about fairness. So I decided I'll talk to somebody in the philosophy department at Tufts University. So I walked down to the other end of the campus. The law's up here, the fairness is down there. I don't know what that symbolizes. So I walked down and I met with Professor Aaron Kelly, who, by the way, was an assistant to John Rawls. If you know the name John Rawls, he wrote about fairness. I mean, this is perfect. I said, what a bonanza, what a gold mine of information. So we had coffee and we had a chit-chat for 2 hours. Nothing. I mean, I heard about fairness, but what bothered me is these concepts were not operational. How do I take those concepts and apply them to this very complex factual situation? Ultimately, my colleagues and we decided, no, there was unfair. And I won't get into it, but so we each decided it was unfair. But what was interesting is the rationale of why it was unfair differed between, on the one hand, Professor Pedro Niken and Professor Kaufman-Kohler and me. We said that this is unfair because the legitimate expectations, the reasonable legitimate expectations, this was our standard, of the investors, expectations, after all, created by Argentina, were frustrated. And that was unfair. It's changing the rules of the game in the middle. My Professor Niken agreed with us that it was unfair, but he had a different view. His view was, he said that Argentina did not treat them even-handedly. And I wasn't sure what that meant. But if you go to Professor Niken, filed a separate concurring opinion. So you should go and see that we're trying to struggle with what the hell did the states mean when they said fair and equitable? And how do you apply it to this complex situation? Ultimately, we came out with that. And then the defense of necessity is very interesting. But what was also interesting, we had a group of 5 NGOs who said, we want to come in and make a presentation. And the question is, should we allow it? They want to make an amicus curiae submission. That had been tried once before with another tribunal. The tribunal said, no, there's nothing in the rules that allows it. No. We said, now wait a minute. We looked at it, and there's just 2 tribunals looking at the same rules saying, yeah, that's true, there's nothing in the rules, but there is a provision that says that any procedural question not covered by the rules itself, the tribunal may decide. So we said that gives us residual power. And we said that in certain situations, it is justified. Water and sewage, and Professor Ninkin, who is an expert on human rights, saying there is a human right to water. I said, this is an issue that we ought to hear from these people. So they filed an amicus curiae brief, and we were the first tribunal that allowed that, and following that, ICSID amended its rules to make that very specific, that, and I think other treaties, other rules, the new treaties that have been made since that time have all provided for amicus curiae. And then finally, we went into the damage phases, and that's the end of the day. One of the questions is, of course, we're supposed to give them full compensation. And the issue then is, what's full compensation? You know, how do we know?
Whatever's
In other
fair.
words, you assume that the assumption is, what situation, and there's lots of international law on this, what situation would the investors been in had the treaty not been violated? Well, that takes us to 2030. How can we possibly know what's going to happen in 2030? What situation would the investors been in 2030? How much money would they have made in this project had the treaty not been violated? So we really had to speculate. And what we did was to look for an independent financial expert to help us. And we found an expert who happened to be at the Kennedy School. Although I spent the whole summer on my telephone calling all over the world looking for somebody who was independent, and this was the problem. So many of these economists could not have worked for Argentina. He could, or she could not have worked for any of the parties, nor could could this expert be involved with any law firm that had sued Argentina or had represented anybody. We really wanted somebody that was independent, and we finally found him, Professor Akash Deep, at the Kennedy School. So we ultimately came out. So
I think we can go on to
here we are again. This is we're
leaving town.
happy crowd. Let me just kind of finish up. I think there's some criticism of interstate arbitration. One is lack of transparency, secrecy, and I think efforts could be made more to do more about that. The convention says, or the rules say, no decision may be published by ICSID unless agreed to by both parties or other parties. I think that's a rule that's uncalled for. Mm-hmm. I think that all decisions of ICSID tribunals should be published and made public. Often there's a lack of consistency among awards, and that's the problem because you have separate tribunals who are who are dealing with some of the same language, but tribunals can differ. And there's no appellate body. Third is there's a lack of there's a criticism, there's a lack of regulation and controls over arbitrators. I'm not sure to what extent that really is legitimate, but we can talk about that. Finally, there's a lack of, it's often said there's a lack of finality, because if after an award is made, if the tribunal, if the one party doesn't like it, it can request an annulment process, where another committee is appointed and will decide whether to annul the case or not. If the case is annulled, that is not, all that means is you start all over again. So there was also an issue of carnalities. These are very costly. But the cost is not the arbitrator, I assure you, it is not the arbitrators, it's the lawyers. These are big law firms that are throwing in lots of people who they are that's
over years.
the legal over years,
right?
Absolutely.
So.
And there's the issue of whether the public interest of host countries is protected. So here's some possible reforms. Lastly, make publication of all awards and decisions mandatory. Second, open the proceedings to the public. I see no reason why these proceedings themselves should be closed. Second, allow amicus curiae. Well, that's happened now. I think that's more accepted. Create an appellate body. This has been talked about to try to bring some consistency. That's one of the functions of appellate courts, to create consistency of decisions and jurisprudence among lower courts. And I think there should be a more active use of ADR, alternative dispute resolution mechanisms, mediation and negotiation. So, with that kind of quick overview of the secrets of a secret tribunal, I'll turn it over to you, Mike.
2 questions.
Yeah.
Thank you, Jess. That was
Yeah, it's great.
extremely informative. I really appreciate it. First, what is the status of decisions in U.S. domestic law? Are the underlying treaties self-executing, non-self-executing, which has been set by the courts to affect that? And second, just to get this out,
Yeah.
Trump has, of course, suggested he's going to go around terminating or renegotiating a lot of these things.
Yes.
What does the termination procedure
Right.
look like?
Well, on the termination issue, I think it's important to realize, and he doesn't realize that, because I don't think he's read anything. But if you read the provisions on termination, it says, you can terminate, there's a process you can go through, so each state can go through as of a certain period. But it says that any investment made while the treaty was in effect shall continue to be
Right.
protected by the treaty for a period of years. And that makes sense, because these are long-range commitments that are being made. The investors are relying on the treaty. So if you suddenly pull the rug out, it's not really fair. So new investors are not going to be protected once the treaty, once a state exits from the treaty. But the existing investors and investments that were made while the treaty was in effect continue to be in effect, continue to be protected, and can bring a case under the investor-state dispute settlement provisions. In American law, I mean, you've got, for example, you've got the NAFTA, which I think was ratified, and there is a law providing for its enforcement, and all the bits that the bilateral investment treaty that the United States have been ratified by the Senate. Yes.
This is a procedural question. I'm
Right.
wondering, in these bilateral investment treaties, is there usually any provision that would require the aggrieved investor to try to find a remedy in a domestic court before they go to arbitration?
Yes, that may be. No, that was the case in some of these treaties. In our case, one of the is that there may be a provision that says before you can invoke arbitration, you must try to negotiate for a period of time, or B, bring a case in the national court, the court in which the investors, where the investment is made, and that again can't go on forever. And if you do not get a satisfactory result in 18 months, then you can invoke arbitration. So this is, I think, more and more standard, and I think that's fine. I think that there should be an effort to use ADR. I mean, remember the first time I was confronted with the process, first hearing I chaired, kind of the doors open and this parade of people walked in. On one side, on the other side, we were operating in Spanish and English. We had Spanish and English translators. We had court reporters. Everything is recorded, and the teams of each party were numbered in 10. Must have been at least 10 people. And one thing that having put my negotiation hat on, because I do teach negotiation, I said my first reaction is, there's got to be some better way than this. This is expensive. Well, I'm not quite sure I know what that is, but I hope that there is a way. And I think more and more you're finding in some of the treaties some encouragement that the parties undertake an opportunity to use alternative dispute resolution to resolve their problem. Tony?
Oh, just on that point, if you have a provision for a requirement for 18 months or whatever period to go into the national courts, isn't that exactly what the arbitration clause is designed to prevent? The possibility of bias or inadequate care, particularly in less developed countries.
Well, first of all, it's framed, often developing country judicial systems often are extremely slow and cumbersome.
Yeah.
So it says there's usually a time limit. You try as long as you can. And if you're not satisfied with the decision, if you get a decision, even if and you're not satisfied with it, you can still bring the case. Because one of the reasons, I mean, again, going back to the TPP debates, people said, why can't we use American courts? Why do you need this group of folks? And the question is, how do you protect, what foreign investors are worried about is hometown justice.
Yeah, exactly.
They're worried about bias in the court toward against toward the host state.
Yeah.
I mean, in many countries, how many? You have to ask yourself, how many judges in countries have the nerve or courage to render a decision against their own government? A lot of places, that doesn't happen. Yes, and if you're concerned about the treatment of foreigners in our courts, we like to think, oh, well, this is wonderful. I suggest you look at the Lowen decision. Lowen against the United States. The treatment that, I think it was out in the state of Alabama, that Canadian investors got in that court, which was outrageous, frankly. So it is the potential for bias in favor of the host
So
state is always there.
why sign that provision at all?
Which? I think it said, look, if we can sell, if this kind of goes back to exhaustion of local remedies, what's the underlying notion? If we can settle it, if you can settle it in our courts and you're satisfied, so be it. Like, the matter ends there. But let's try.
Joel and Marlene.
Yeah, I'm sorry.
Well, isn't it also easier to enforce if you get it
Right.
settled, or if you take care of it in the local court?
There's no need for enforcement.
Right. 'Cause-
In other words, if you negotiate with, in this case, if you negotiate and you come up with a settlement that you find, okay, it's not everything I wanted, but it's enough.
Well, I just,
Because the other thing you have to ask yourself is, the investors like this are saying, we're investing here for the long term. If we sue these guys, if we sue the host state, we are rupturing, that's the end of it. We're rupturing our relationship. So, and we've put a lot of money into building a relationship with the host state. So,
I just mean actually getting your money. 'Cause
Yeah.
generally
you
you
mean-
have to
oh.
take this decision back to the host state's court or wherever the state has money.
Yeah.
Right, so if you
Right.
could take care of it in their courts.
well, on this
you
case,
skip
I
this
should
step.
tell you that there was a piece of the case that was not governed by ICSID, but was governed by what we call the New York Convention. And under that,
That's enforced.
So it was enforceable, it could be challenged here in the state. So Argentina went into the District Court of Washington and challenged it. Said this decision, and listed the various points. These guys, the secret tribunal was wrong on the following reasons. Here they are, Well, I'm very pleased to say that the District Court upheld the tribunal on all points, saying no. So, and said it should now be enforced. So they, as far as that piece, which is about $20 million, the investors, which were the English investors, could take that, can now take it and try to negotiate a payment from Argentina or try to levy on whatever assets are not covered by sovereign
Although we
immunity.
could have had a separate full
Yeah.
seminar on
Right.
collection
Yeah,
against
this is a whole
Argentina,
thing.
but
Yeah,
that's
this is
another
another
one. And I think we have time for a
Not-
couple more questions. Yeah, no?
Thank you. On the issue of jurisdiction, what happens if jurisdiction is declined? Are you allowed to follow shop or?
If jurisdiction is, we decline jurisdiction, that, as far as this tribunal goes and as far as ICSID goes, that's it. It's all over.
Could they try to?
They could take it,
Local court.
they could try to get it annulled. I suppose that is that, but normally if you lose on jurisdiction, you might see if there's another tribunal that's available for you under maybe another treaty or another set of another recourse. But normally, if you look at the cases that have been to ICSID, once a decision has been made that there is no jurisdiction for whatever reason, then the matter usually ends right there.
One of Joel or Marlene?
Yeah.
Okay.
Okay, one short question. especially in the context of free trade agreements. Is there a way, or is there an idea or efforts to make this more accessible also for smaller investors, medium enterprises, which might come more to the scene and often don't have the resources to?
Well, the investment provisions within the free trade agreements cover small investors and big investors. But just as in the commercial area, you have to make it before you bring a case, before you sue in the courts, you have to make a decision, is it worth it? What are my costs going to be? And that decision has to be made by the investors. But you can get, for example, I'm thinking of one case involving a group of investors, it was an investment engineering company that went to Sri Lanka, and it negotiated for a long time, and it kept getting encouragement from Sri Lanka, and it spent probably over $1 million on just the process of putting together proposals. And then at the end of the day, Sri Lanka said, no, we're not interested. So the investors sued, and the tribunal said no jurisdiction. But the investor obviously made a decision that it had lost enough money that it was worthwhile bringing a case against Sri Lanka.
And maybe just, Joel, I think you had a question, and then we'll wrap it up, call it
I
out.
wanted to ask you more about applicable law in the tribunal. And you mentioned the treaty itself, the
Yes,
Exit Convention,
yes.
the Vienna Convention on the Law of Treaties,
And the national law itself.
national law itself.
Because-
But what about, so my question is about other international law. You mentioned that Professor Nikin referred to the human right to water.
Right.
So is that under the specific terms of a provision authorizing you to apply that, or was that just an interpretation?
One of the interesting things, we talk about damages, everything about, most treaties say nothing about damages. I mean, so one way you can interpret this is to say, well, if they they don't authorize specifically damages, are you authorized to do it? You can take that and say, why didn't they say that? Why didn't they say, in the event of a violation, the injured party can bring a case and sue for damages? The way the tribunals have almost virtually uniformly have said, there is a provision that says the tribunal shall decide matters, and it indicates what sources of law it should use, would be the treaty and general principles of international law. General principles of international law brings you right up to the issues of compensation. So lots of treaties these days are applying the articles on state responsibility because they talk pretty specifically about damages. That you have a right, you have the obligation to come to compensate, and the compensation should be full compensation and so forth.
Interesting.
So what's very interesting, so I have a new chapter in my second edition of my book where I kind of talk about that. I thought it was really interesting. Why didn't they say anything? And I have two hypotheses. One is that talking about damages when you're negotiating may scare off the other side. What? We're going to have to pay? The other is talking about damages when you take those treaties back home to the legislature. They will say, what? Are you kidding? We're going to have to pay these guys? Oh, no, this can't happen. So I don't know to what extent my cynical view of politicians is, but that I think that may explain it, because the tribunals have said, look, it says principles of international law. You're authorized to apply principles of international law. Principles of international law on compensation for wrongs, state wrongs, is clear. Let's apply that. And that's what tribunals have done.
And I think on that note of realpolitik, we want to thank you for a great overview and discussion.